Hi, everybody. Welcome to the May edition of Sprint Law's monthly webinars. I'm Alex Solo. I'm the co-founder of Sprint Law, and today we're going to be talking about protecting your brand, IP, and trademarks. Um, just to give you a quick introduction to who we are for those who are not already clients, Sprint Law is an online law firm designed for startups and small businesses. We've been around for coming up to 10 years. And unlike traditional law firms, we are designed to make legal services really, really simple for smaller companies. We don't charge by the hour. All of our services are done on a fixed fee basis. We cover most of the different areas of law that businesses might need help with, from helping you set up your company, getting your terms and conditions done, employment contracts, data and privacy law, uh, capital raising if you're a startup company, contract drafting, and as we'll be talking about today, protecting your intellectual property and IP registrations. We have an optional membership. Most of our clients sign up to it. It's a pretty low annual fee and gives you access to unlimited quick calls with our lawyers, bunch of legal software tools to make free legal docs and e-signatures, and some credits to use on legal services throughout the year. So if you use us a couple of times a year, it usually pays for itself. And there's a free version if people want to check it out on our website. Um, a bit more about us. We're headquartered in Australia. We've expanded over to the UK and New Zealand. Actually, this is about our data. We have a bit over 10,000 clients now, and a team of a bit over 50. So, oh yes, and if you are gripped by an inexplicable urge after this presentation to get some advice on intellectual property law, do feel free to book a free consult with our team, and we're doing discounts at the moment for IP services until I think the end of June. So it's a good time to get on top of it if you haven't already. So just into the content for today, we're going to be talking about intellectual property and trademarks. First, we'll talk about what are the different types of intellectual property that you want to be aware of in your business. We'll then talk about specifically trademarks. What are they? How do they work? Do you need to register one? What happens if someone else uses your trademark? We'll then talk about copyright. What is it? How does it differ from trademarks? What kind of protection does it offer your business? How could you make sure you're not accidentally using someone else's copyright? And then finally, we'll talk a little bit about NDAs and confidential information, which is not technically IP, but often comes up in these kinds of conversations. As I'm going through, Zoom has a Q&A feature. Do feel free to use it to ask questions. I'll keep an eye on it as I'm talking. We might have a little bit of time at the end for some questions, but also if you want to ask while I'm talking about a particular topic, do feel free to. I don't mind answering as I go. It can often add a little bit more color to whatever I'm talking about. So let's start at the beginning. What are the different types of intellectual property? And in fact, what is intellectual property? Well, intellectual property, as the name suggests, refers to any intangible assets that your business may own, as opposed to physical property. And the reason that you want to understand what intellectual property your business owns is you want to protect it because it may be valuable to your business. It may not be physical property that's valuable in a physical sense, but it might have other important commercial aspects for your business. So the law recognizes many different types of intellectual property. The main ones that come up for businesses are on screen here. So we've got trademarks, which are designed to protect your brand, your logo, your sort of brand identity. Copyright, which is meant to protect creative works, original works, your writing, your blogs, your pictures, those sorts of things. Confidential information. This is commercially sensitive information that might be really important to your business. It might not be copyright in the sense of it being a creative work, but it might still be, some sensitive business strategy or something else that you want to keep confidential and you don't want others to know about or use. We have designs. We won't be talking much about this today, but for furniture or product businesses, if you come up with a unique design or shape of a product, that has its own form of intellectual property. And then patents or patents, which are for inventions, sort of scientific inventions, vaccines, robotics, and other discoveries. Again, we won't be talking much about that today because it's for a fairly specific type of business. Except to say that a lot of people do ask us when they're a small business, they've created a a software or some other kind of app or something, and they'll say, "Oh, can I patent it?" The answer is usually no, unless it is a really major discovery or invention. The appropriate IP for protecting normal software creations is usually copyright, which we'll talk about a little bit later. So we'll spend this presentation on mainly the first three. For those of you who have questions on the others, I'll see if I can answer them if you want to ask them in the Q&A. Otherwise, you're welcome to reach out to our team. So let's start with trademarks. So what is a trademark? Well, a trademark is not just a brand name or logo, it's an identity. And this comes straight from IP Australia's website. So that's kind of how they describe it. And it's a tool that will help differentiate your brand from those of your competitors. So you can trademark a letter, a number, a word, a phrase, a color, all these different things, smell, shape, logo. Once you've registered a trademark, you have the exclusive right to use that brand name, that logo, that phrase in a particular country and in a particular class, which is sort of like an industry. So you can see in the corner we have Sprint Law, we have the word Sprint Law, which Sprint Law is trademarked, and we also have another registration for our logo, which has this little S shape, and we've registered in class 42, I think, which is the legal industry class. And so that means nobody else in the legal industry can use the word Sprint Law or anything deceptively similar to a Sprint Lawyer, Sprint Legal, nor can they use that little S-shaped logo or anything too similar to it in legal. We have the exclusive right for 10 years. We've paid a registration fee with IP Australia, which we're going to now. We've passed some tests to make sure that it's actually ours and it's original to us. And now we own this brand. People in other industries, I mean, if you started a restaurant called Sprint Slaw that sold really fast coleslaw, and you wanted to get a trademark, it'd be a terrible name, but if you want to get a trademark for that in the in food and hospitality or whatever, that may not infringe our trademark. But if you wanted to start Sprint Legal or Sprint Lawyer in the legal industry, that likely would infringe our trademark. It doesn't have to be an exact match to infringe your trademark. It's quite a strong protection having that trademark registration, which is important for you to know for your own brand, that it's a very powerful thing to own, and also to be aware that if you haven't got something trademarked, you might have not found anyone out there with the exact same name as you, but you could be unknowingly infringing someone else's trademark because it's not just about an exact match. And particularly if you use like a logo stamp, if someone used this logo stamp but had a completely different word here, like Spirit Legal, but they use the same stamp, they could also potentially be infringing our trademark. So that's kind of how it works. There's some other examples here. Arnott's have a word mark for Arnott's. The difference between a word mark and a logo will protect the particular, green style with the stamp thing version of your brand name. Arnott's, who have a word mark, any time the word Arnott's is used to promote goods and services, it could potentially be infringing Arnott's trademark. And we also have a word mark for Sprint Law. So any use of Sprint Law to promote goods or services without our permission could potentially be infringing. And then of course you can do colors. So Cadbury have famously for chocolate trademarked this specific shade of purple. They don't own the purple, which is a common misconception in general. Like you can color things purple for your business and use very similar shades of purple. But if you start selling chocolate in packets that is very purple in the distinctive Cadbury purple, and you're essentially, the argument is you would be trying to trick people into thinking that it was a Cadbury chocolate. Cadbury can say, no, that's our purple. And then yes, we have logos as well. So there are all kinds of things you can trademark. In general, the vast majority of our clients are just trademarking their name, ideally as a word mark if they can, as well as their logo, and in some cases their phrase, like "Just Do It." Sprint Law has a trademark for business legals made simple. So you might do those three, unless you're in a business that's heavy on brand, in which case you might want to do colors or other sorts of things. Um, I'd say 90% of our clients are doing sort of those three. So hopefully that gives you a bit of an overview as to how trademarks works. Lawrence has asked the question, have you extended to other countries for your trademark? Yeah, so just to touch on how it works with other countries. So when you register a trademark, as I said earlier, you're registering in a particular class or industry and in a particular country. So to use the example of Sprint Law, we have an Australian registration for Sprint Law in the legal industry. We had to get a separate registration in New Zealand, a separate registration in the UK, a separate registration in the US, where in fact we had some difficulties because there was another business with a similar-ish name, and it was not straightforward to get that trademark registered, a separate one in Canada, and so on and so forth. So just because you have a protection in one country does not give you this exclusive right to use your brand in other countries. And if your business plans to expand overseas, if you had unlimited money, we would suggest from day one to get it registered in all the countries that you plan to go to. If you can't afford it, you can do it progressively over time, and that's what most businesses do. And in the case of Sprint Law, we only did, I think, Australia and the UK early on, and then later on we added on the other registrations. But it can be risky because we've had clients who started in Australia, grew their business, didn't expect to expand overseas, and by the time that they did, they'd missed the boat and someone else had their trademark. So you have to do them separately. You don't have to go necessarily find lawyers in every country. There's something called the Madrid Protocol, which Sprint Law uses and many other Australian law firms use, where you can quite easily upgrade an Australian registration to a global registration. And so often it's handled that way. But it is a separate registration for each country. I can see a few other questions come through around trademarks and one on copyright as well. I might just keep going through because I think we will come to the answers for some of these. But just to continue on, so we've got the concept here of a trademark and how it works. Here is a bunch of examples of trademarks you may be familiar with: a letter, a number, a word, a phrase, color, sound, smell, shape, movement in some cases, believe it or not, can be trademarked. Now, this is a really common misconception. Most people, when they've set up their business, if you're a sole trader, you might have got an ABN. If you're a company, you might have set up an ACN. You will have chosen a business name or a company name. And a lot of people think, oh, and there's laws in Australia where your business name can't be identical to any other registered business name. And so a lot of people think, oh, I registered my business name, therefore I own it. No one else can use it. And similarly, I set up my company, my PTY Ltd company. I had to get a unique name, therefore I own it. No one else could use it. That is not the case. You need a separate registration to actually own your brand. You can see on the right in the example of Nestle. Nestle's business name is Nestle Australia. Nestle's company name is Nestle Group Pty Ltd. Neither of those things by themselves give Nestle any right to the word Nestle. Nestle has a domain name, which is its own thing as well, nestle.com.au they had to get. And then Nestle has a bunch of trademarks. They have one, of course, for their business name. Then they have separate trademarks for each of their products, Uncle Toby's Oats and Nancare. And so that means no one else can use these brands. So you want to get a trademark for your overall brand name and also for any other product brands you may. I mean, you can think of the example of Apple. Apple has a trademark for Apple. It also has a trademark for the MacBook and for the iPhone and for the AirPods. Those are not business names, but that means I might be able to register a business called AirPods Pty Ltd. Maybe that doesn't exist, and ASIC would let it through. I start trading, Apple will sue me for trademark infringement, saying you're using the word AirPods, provided it did in fact infringe their mark. So hopefully that helps you understand this difference between a business name and a trademark. And for many of you thinking, oh no, I've got mine already. If you haven't actually registered with IP Australia, you don't have the trademark, and it is one of the top, if not the number one, most missed issue by small businesses is this not actually registering their brand name and then having to rebrand a few years down the road. Yes, I won't go into this in great detail, but this is just laying out in a bit more detail the difference between a business name and a trademark. And if you've just got a business name, key point is you can't stop someone else using your brand. Someone else could go ahead and register a trademark after you started your business and potentially stop you from operating in some cases. So they're different in that sense. A trademark registration, though, is not required. Like don't need to do it. It's just a really good idea. And so for most businesses, I would suggest doing it. But again, you don't have to. It's just a really good idea to protect your brand. And if you don't get a trademark, and this is sadly stories that we've seen play out with many of our clients, you have to potentially rebrand. And there's many clients of ours that, had been around for 1, 5, 7 years, in some cases over 10 years operating without a trademark, without realizing they were infringing someone else's trademark in the meantime. And then their business started to do well. They started to get a bit more promotion. And one day they received their trademark infringement letter saying, hey, you have to change your brand name and also pay us money for trademark infringement. And sometimes they can fight the battle and win and say, no, we've actually owned this brand for ages. There are arguments where you say we technically have an unregistered trademark, blah, 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 blah. But in many cases, the business who didn't have the trademark has to rebrand. And that can be very expensive because if you got logos, if you've got a shop, if you've got stock, you've got products, you've got goodwill, all of these different things attached to your brand, and you didn't secure that trademark, it can be very expensive. And these are some stats from IP Australia on like the average cost, and the percentage of people that had to rebrand. So in your to-do list, if you do things the right way, and this is kind of what I say to people when they're asking me, how should I set up my business? I often say, get your company registered. Ideally, if you can afford it, number one, and your business partnership agreement in place if you have business partners, number two, and then number three, trademark. Like it's right at the beginning of the business because you want to make sure you got that brand secured before you're spending a lot of money promoting it. So if you hadn't done it early in your business setup, which again is very common, there is no time like the present to get on top of it. The IP Australia put out a report recently as well, which is interesting, showing that businesses that own their brand with a registered trademark saw an average 16% increase in sales per worker compared to similar businesses without IP. So IP Australia are kind of making the case that it has a real commercial impact if you can use that little R logo and build trust by saying that you have a trademark and so on. That helps build the business. Could be correlation, not causation, of course. So one should take these stats with a grain of salt, but it is interesting to see that trend over time. And as awareness increases, more and more businesses are getting trademarks, which is good to see. But yes, IP Australia, I think, is making a pretty strong case that businesses who are on top of their IP are found in general to do better than businesses who are not. So when you are registering your trademark, you're going to need to pick the goods and services that you register for, and you're going to need to also pick the industry that you register in. So you want to be figuring out, okay, what is it that my business does? In Sprintlaw's case, it's quite straightforward. We do legal services, legal software. Some businesses might fall across different categories. Some businesses might do hospitality and software. You might be a food services business that also has some technology, or maybe you're a clothing business that also is an e-commerce business and there's a technology component as well. So sometimes you have to register across different goods and services and across different industries if your business straddles two industries. Again, I say have to. You don't have to do anything, but it can be good if you want as broad as possible protection. So many of our clients will end up registering across multiple classes and across multiple goods and services. That's one thing that you need to think about. And you can see here, when you register a trademark, as I said earlier, it's in a particular class, in a particular industry. So take the brand Antler, for example. On the IP Australia register, there are multiple trademarks for Antler, the brand Antler and the word Antler. One is a venture capital firm called Antler, another is a luggage company called Antler, and another is a safety helmet called Antler. So all three of these were permitted by IP Australia because even though they're the same, they're trademarked in different areas. But in the case of chocolate, you've got to be quite different to other chocolate brands if you want to register in the same class. So, you know, you've got Cadbury, Snickers, and Dara Lee, which are all distinct from each other, but they're in the same category of trademark. So again, re-emphasizing the point that it's very much about what goods and services, what industry that you're in terms of what gets protected and how the trademark works. In addition, there's rules around what can and can't be trademarked. You can't trademark an everyday word in general. Now that's looked at in combination with the industry that you're registering in. Apple's a great example. Apple could not have registered a trademark in for fresh fruits because it's literally a description of a type of fresh fruit. So they couldn't say we're creating a fruit trademark called Apple and no one else can say it. That's too generic a term. But in the case of computer equipment, Apple has got nothing obviously to do with technology. And so they were able to secure a trademark in technology for Apple because it was not generic. But you may find that your business name or your brand name that you want to trademark, you go and apply with IP Australia, you may find that it does get rejected if the name is found to be too descriptive and the kind of thing that people in your industry would use anyway. And so it has to have this kind of distinctiveness element for it to be approved as a brand name that you can own. You can still operate a business with a descriptive name. It's just that you won't be able to get that kind of trademark protection for it. And then just on this question, when is the right time to apply? I mentioned this earlier. My view is it's one of the things you want to do fairly early in your business journey. So for those of you thinking, oh, I've been around a while and I haven't done it yet, my suggestion is to think about doing it soon. There's always a trade-off if you're just setting up your business and you're in the very early days. If you haven't fully settled on your brand name and you're worried that you might change your name in the first 6 to 12 months, you can wait and register later. You just got to be aware that there's always this risk that if you wait a year or 2 years to get that trademark registered, in that time someone else has beat you to it, and then it becomes a really big battle for you to get that name. So it's can be a good idea to secure it if you can afford it as early as possible. But just be aware if you choose to wait because you're not sure yet. That's a defensible choice, but just carries a little bit of risk. In terms of how a trademark registration works, it's not a very fast, instant process, unlike, for example, registering a company. IP Australia have done their best to make it easier for small businesses over the years. About 7 or 8 years ago, they launched something called Trademark Head Start, which is one of the simplest way to get a trademark registered. Basically, the process takes at minimum about 6 or 7 months. And if there's an issue, it can take a little longer from filing to I have my certificate, I own my trademark, which again is a reason that you want to start early. If you use the Head Start process, you find out pretty early on, you get like a preliminary assessment, usually within a couple of weeks from IP Australia as to whether you're likely to get approved. But the actual process is you'll submit a trademark. If you use Head Start, you get this preliminary application saying likely to pass, likely to fail. Then you formalize it into a full application. Then you wait a month-ish. You receive a formal report from IP Australia saying we formally accept it or reject it. They might reject it for being too generic or too similar to another trademark, so on and so forth. Even if they approve it, there's still another 4 to 6 month waiting period where your trademark is essentially in a pending state for any other trademark holder to say, I'm not okay with this, I oppose it. Even though IP Australia thinks it's okay, I think it's too similar to mine, and I'm going to challenge this registration. And so it's both up to IP Australia and other trademark holders who have the right to oppose for you to be able to get your registration finally. And for most clients with a distinctive enough brand name, this process just goes through fine. They pass the formal report. There's no oppositions, then it gets registered. That is definitely the majority of cases. But for a non-trivial minority, something goes wrong. You get rejected at the formal report stage or at the Head Start report stage because it's too generic, and they suggest that you maybe change it and try again. Or even if you get it through, some other brand emails you or lodges a complaint with IP Australia saying, we'd like to oppose this application. And then there's a dispute process where IP Australia um, will allow you to respond to their opposition. And you can defeat it and still go to registration, but it can make the process drag on a little longer. So um, in simple cases, the process at best will take 6 or 7 months. It's not tons of work. You just file the application and wait to receive the results. And in more complex cases, you may get an opposition, and then you may need some advice on how to handle it. Yeah, that's kind of how it works. IP Australia launched, I think, 18 months ago, something called the Trademark Checker tool. So for those of you who want to, you're worried now someone else might have your trademark, you can check it out. And I think the URL is here, tmchecker.ipaustralia.gov.au. You can just Google Trademark Checker tool, IP Australia, and type in your brand name or business name and see what comes up. The checker tool is a little conservative, so it's going to bring up anything that might be an issue. So don't get too worried if you see a bunch of results that don't look that similar to yours. But it is a good way to find out quickly whether there's something already registered. And if you end up needing some advice, we can, of course, help. And in terms of enforcing your trademark, once your trademark is registered and you own it, the next question is, well, what do I do with that? Well, just the fact of owning it is, as we said earlier, allows you to use that registered R logo, adds credibility to your brand, gives you security that you won't have to rebrand later. So already you get those benefits, but you also have the right to enforce it. If you see someone else using your trademark, you can send them a cease and desist letter. If they keep using it, they have to pay you compensation for using your intellectual property without your consent. And you can, in fact, request any money they've made off the back of your trademark as an account of profits. In many cases for trademark enforcement, it begins with a cease and desist letter, and most people comply with it. So it's not that common that you're suing people, but you have the right to, which can be a powerful deterrent, at least in the case of small businesses. I say for large businesses, there's lots and lots of trademark cases, but in the case of small businesses, it's usually just a powerful deterrent, if that makes sense. So just to go through, we've got a lot of questions on trademarks here. One question is it possible to trademark our likeness as part of the business? E.g., if we're providing information on social media to prevent people from making AI impersonations of us to prevent misinformation. Yeah, that's a bit of a complex question. Potentially, a trademark is, in that case, probably only one part of the protection strategy. Like, it's not going to completely stop AI impersonations. Trademarks, as I said earlier, are really about your brand name, your logo, and your key phrase. There's not really a right to trademark like a person in the abstract. But if you have like a name or a stage name or a stylized image or a catchphrase, all of those things are trademarked. Together, you can end up protecting something sort of like a likeness. Yeah, I mean, if somebody is impersonating you and pretending to be you, you could probably get them for misleading and deceptive conduct. There's many other forms of laws that stop sort of fraudulent behavior and misleading behavior. So trademark may not be the right way to enforce your rights. Instead, you'd say, unless they were using your logo, if that makes sense. But if someone is deliberately copying you and pretending to be you, there are likely to be legal claims that you have against them. So hopefully that makes sense. We've had another question. Once you apply for a trademark, is it possible to change or update it? um, to the extent that you want to add additional classes. Um, you can you can add um, um, yeah, you can add additional classes, but not easily on your existing application. So um, usually, if you want to update like the owner details or change the goods and services or clarify the wording or change the address, all of those things are fine. But mid application, you can't add a new class um, uh, or add another registration and have it on the same timeline. You would have to file a new application basically. So you'd be on a separate timeline for the different class. So I mean, the answer is yes, you can do it. It's just that you can't do it as part of the same application, if that makes sense. Um, Another question from Jermaine. Um, I just checked the trademark I'm interested in Australia. This is what I get from IP Australia lapsed. Um, what does that mean? And also, is the class, I think that may be a separate question. So is the class 24 the industry vertical in which the trademark is limited to? Broadly, yes, that's right. As I was saying, class, I was using the term industry, which is not quite right, but classes are sort of like industry. So for example, there's the legal class is where Sprint Law is registered. I think it's class 42. And so you've mentioned class 24. Yes, that's essentially like the industry, or more like a category of goods and services, if that makes sense. So hopefully that answers that question. And then in terms of what a lapsed trademark is, that usually means what happened is the trademark would have been filed. IP Australia would have given an adverse report for some reason. Maybe the trademark name is too generic. Maybe it infringed someone else's trademark, and the person did not decide to challenge it. They just let it lapse. So it could either be, if you're interested in that trademark, it could either be um, good news because they didn't go ahead and get a registration, so you can now try, or it could be bad news because there might be some reason that it got rejected, and that could apply to you if you tried to register. So you might want to get a little bit of advice on that one from one of our trademark lawyers before deciding to apply, given that there was some issue with it in the past. Um, uh, Lawrence asked if you're not planning to have a business office in the USA, but you have um, customers there, e.g., software or digital content delivery in the USA, do you still need to register your trademark in the USA? Great question. If you are selling software to customers in the US, need is a strong word, but it would be a good idea to register a trademark in the US as well if that's a substantial market. It's not really about whether you have an office there, it's about using that trademark in that region, which obviously when you're an e-commerce business or you sell online, you're based in one place and the customer's based in another. In general, crudely, it's understood to be if you're marketing to customers actively in that region, then you would be operating in that region and then you could receive a cease and desist. So if you don't own a trademark in the US and you're marketing in the US, you have customers buying stuff from you in the US, you could receive a cease and desist, and someone could launch an action against you for infringement of trademark, and you might need to rebrand in the US or cease operating there. So it would be a good idea because you wouldn't have protection from your Australian mark in the US just because you might be based in Australia. So hopefully that answers that question. And I said, can you provide some guidance on costs? Yeah, so IP Australia charge I think $330 for as a registration fee. It varies a bit depending on whether you use that Head Start process or not, but it's something in that range if you try and do it yourself. If you want legal help on top, we charge an extra, I think $400 for one trademark. So if you do it with a lawyer, you're looking at say $750, $800 for a registration, inclusive of all the fees. It gets more expensive if you want to register a name and a logo, and you want to register across multiple industries because there's specific costs for additional classes. But if you're doing two classes in for two trademarks, it's probably going to be something like $1,300 to $1,500. So yeah, cost varies, but it's in that ballpark. If that makes sense. Lots of great questions here. conscious of time, I'll go through a few more and then maybe keep continuing on. Vijay's asked if one company has multiple businesses, can they use a different name for business? The company name would be the same. Is that understanding correct? Yes, that's possible. So you can have a single company that has multiple brand names and business lines. Yes, you can have different trademarks for them. You could even register different business names for them, which you may have to do. So, for example, if you were called Computer Services Group Pty Ltd, and you had like Joe's Hardware Repairs, Joe's Software Services, Joe's Cybersecurity, those could be three brand names under one company. You need to get business names for each of them because the business register requires that if you're going to the public under a business name, that's registered with them so people know who's behind that business name. And then you would also potentially get three trademarks for the cybersecurity, the software, and the hardware business. But you could do it all under one company. You might not want to because now all of your accounting, your profit and loss, and everything is done under one company. So people might prefer to separate it from a business perspective, but it could theoretically be all done under one company. They're separate concepts. Diane's asked, do I have to trademark my business name or my company name? You should trademark the name that you use to market to customers, like your brand name, which might be the same as your business name, which might be the same as your company name. It depends what you've called your company and your business name. In many cases, we are, for example, Sprintlaw Pty Ltd is our company name. We have a registered business name of Sprintlaw and we have a trademark for Sprintlaw. So we've done all three in that case. But other people may have called their company something different. Okay. Lots of great questions. I might just move on to copyright and then come back at the end, and I'll try and get to all the questions if people want to stick around. So let's move on to copyright now. So copyright is a completely different form of intellectual property protection to trademarks. The idea of copyright is to protect creative original works expressed in material form. So where trademarks are about logos, business names, brand names, key phrases, copyright is about original works. It can be about songs or plays or books or paintings. It was originally designed for arts type work, but in business has been expanded to apply to things like blog posts or software code or graphic designs or marketing materials or advertising jingles or social media videos. All of those things are somewhat similar to the books, the paintings, the music. And so in business, copyright plays an important role in protecting these creative original works. Now we've got this underlined sentence expressed in material form. For something to attract copyright, it has to have a manifestation. That can be a digital or a physical manifestation, but it can't just be in your head. It's famously taught in law school that there's no such thing as copyright in ideas. So copyright is only something that exists in embodied creative work, if that makes sense. Unlike trademarks, copyright is not registered, or at least not by law. It doesn't need to be registered. A trademark, you go to IP Australia, you wait 7+ months, as I described earlier, you get a registration number, you get a little R logo. That's how you get a trademark. You pay a fee. That's how you get a trademark. Copyright is completely different. There's no Copyright Australia that you go to and get your copyright registered with. Copyright is owned by the author of that work at the moment of creation. It automatically attracts copyright. If I create something that's original and I'm, writing a novel and I put a full stop at the end of my novel, at that moment I own it. And if someone comes over and reads it and reproduces a substantial part, I can already say that's copyright infringement. I didn't need to go register my novel somewhere and so on and so forth. So that's an important concept to understand. A lot of people ask, do I need to register my copyright? No, you don't. Now, there are companies online, third-party services, organizations called copyright registration agencies, which you might see online. You can go and log your copyright online and say, on this day, I wrote this novel and here's what it is. it's not a government requirement, but people do it just so that there's evidence that it really was theirs. Because if you ever want to make a copyright claim, you have to show that you actually came up with it. Um, uh, but you don't need to do that. And most small businesses don't actually do that. They just make sure that um, they record the fact somewhere that they created it and the date that they created it. So hopefully that helps clarify the difference between copyright and trademarks, and to give you a bit more of a sense of what we're talking about in the case of copyright. As I said earlier, paintings, graphics, and so on. Um, that's considered artistic works. It's one of the types of copyright. We've got literary works, novels, textbooks. Computer software, I bolded, is considered a literary work. That's how it's been squeezed into copyright law. Musical works, dramatic works. We've also got films, video recording, so advertisements, music videos. So a lot of social media content might be captured here, and so on and so forth. So as I said earlier, it arises automatically upon creation. There's no registration system. Now, once it's owned by the author, copyright can be transferred by written agreement. And so what often happens in a business, and most people here would have either seen or signed an employment contract in their lives, um, your employees might create original works for your business. It's very important that they have an employment contract with you, which has a paragraph in there, the IP clause, that says you agree that any copyright you create in the course of your employment is hereby upon creation transferred over to the business. And if you have that wording in your employment agreement, then conceptually what happens is an employee might create or author an original work, and they sort of own it for a split second, and then under the employment agreement, it gets transferred to the business. So the business ends up owning that copyright. So what's important for you is if you have anyone, whether it's an employee or a contractor, making this kind of stuff for your business, computer software, social media content, graphics, designs, blogs, whatever it is, you just want to make sure that somewhere they've signed a document that acknowledges that that is owned by your business, because you want that to be owned by your business. You want it to be your business's intellectual property, and you want to make sure it's protected and not technically owned by someone who wrote it. And the most common way to achieve that is through, as I said, an employment agreement. If the person making the work is a contractor, you can sign a contractor agreement. If you're now thinking, oh no, I got someone to make some amazing stuff for me, which is probably copyright protected, and I don't think we signed anything, there's these documents called IP assignment deeds that you can use to sort of retrospectively get the copyright assigned to you if it was created in the past. So we often give those to clients. But the main goal here is with copyright, in the case of trademarks, got to go register. In the case of copyright, just need to make sure it's documented and you have a written contract showing that it's yours. Now, once you own copyright, just like trademarks, you exclusively have the right to use it, to reproduce it, to publish it, to communicate it. And if somebody else tries to use your copyright, um, um, uh, then you can sue them for copyright infringement. Now, copyright's an interesting one because unlike a brand name, which is relatively short, copyright can be very long. It can be a whole video or a whole novel. And there are all these cases where people are plagiarizing bits of a blog post or little bits of a video, or chopping clips and reusing them, or images that have been created by someone, or graphics. Is that copyright infringement is a common question. Plagiarism is not a legal concept, but it is not a bad way to conceptualize how copyright infringement works. What you have to show in general in copyright is that a substantial part of the original work was reproduced by someone else. It doesn't have to reproduce the whole work. So, in the example of a novel, if someone takes a chapter, then you could establish that that was an original chapter as part of a broader work. That was an infringement. There's many cases people may have seen in the media with songs where someone's taken a bit of a song, a sample of a song, and used it. That may be copyright infringement depending on what was taken. So that's how you think about it. It's not just about full copying, but partial copying can also be infringement. In terms of the time period, where trademarks are a 10-year registration that you have to renew every 10 years, copyright lasts for a very long time. It lasts for 70 years after the death of the author, or if it's not known who they are, that's 70 years from when it was created, in most cases. So It's a very long time. And again, it's about the author's date, which seems odd because you'll employ somebody, their copyright will be owned by you. But the length of ownership depends on their lifespan. Um, but um, but that's kind of how the law works, and it has this very long time period. So for your business, you just want to be thinking, okay, well, maybe we're not writing novels or composing songs unless you work in the music industry, but what are the business assets that have copyright in them? Common ones are software code, graphic designs, photos, business templates. If you've got original templates, even the way that you issue quotes, if they're original enough, you have collateral that's original, it might be copyright protected. Internal branding strategy, advertising copy, all these sorts of things are copyright. Um, and um, and as I said, you want to identify the important assets in your business and make sure that they're assigned to you. Now, um, there are also considerations for your business in terms of using other people's copyright, other people's intellectual property. Many people running social media accounts or blogs and so on are posting or sharing content. And a question we often get is, am I allowed to share this stuff? Do I need to get permission from the person that created it? I want to promote my brand using this content. Is it okay or is it not? Well, in the case of photos that you might be using, you always want to be checking, is this photo um, someone's copyright? Did I just find it on Google Images and used it without their permission? Or is it actually a true stock photo or royalty-free photo? There are these websites that specialize in providing businesses with free or paid for a small fee photos with unlimited copyright rights for you to use it for commercial purposes. So in general, you want to be using those photos, or if you're going to be using like a different kind of photo, you want to make sure that the photographer or creator of the photo has either assigned the IP to you, assigned the copyright to you, or has given you permission to use it. And again, we see this a lot. Clients will create blog posts or blog content, and then it's increasing now with like AI scanning tools. They'll receive compensation requests from creators saying, "Hey, I saw you've used this without my permission. Pay me this money, or I'm going to take further action." So, to avoid those risks, definitely make sure that you've got the rights to use the photos. Same with videos. If you're chopping up things that aren't yours, there can be risks. Um, and for software developers, if you're using open source code that you found online, there's risks that you may not have permission to use it commercially, and that could also be copyright infringement. So just keep across that in your business when you're using copyright. You may be wondering, you see on Instagram and TikTok all the time, like people posting themselves dancing to famous songs and using chopping up different bits of content. Instagram and TikTok have done deals with major music labels and rights organizations, so they pay fees to allow that to be distributed on their platform, and they often don't allow it for paid content. So um, a lot of the stuff you may have seen using what appears to be copyright infringing content may be just organic content rather than paid content. And many times artists and creators issue takedown requests to tell people to take things offline. And you can be sued by a private creator for using their content on Instagram and TikTok without their consent. So just because you got it on the platform doesn't necessarily mean that it's okay. But that's kind of how that aspect works. So in order to protect your copyright, I would recommend number one, make it clear to people that it's yours. You can use this little C symbol. The R symbol for trademarks is a regulated symbol. You can't use that R symbol unless you own the trademark. This C symbol is unregulated, so you can put that stamp on anything that's original and say, this is my copyright. And that even just putting that there will help deter people from using your stuff. And then if you find someone using your copyright, you may want to get some legal advice to confirm that they in fact are, because it can be difficult to figure out if they are or not. The laws are a little uh, complicated around what constitutes a substantial part, but if they are infringing, you can send them, similar to trademarks, a cease and desist. You can demand money. You can demand that they take it down. You can demand compensation for money that they may have made from it. And if they've posted something online, you can contact the platforms with a copyright takedown request, and they often comply with those if you could show evidence that it's yours as well. So that's kind of how the IP protection works. I'll just finish this slide on confidential information and then dive into the questions because I see we've got a good set there. We've talked about trademarks for your brand. We've talked about copyright for your original works. Confidential information was the other topic that I just wanted to talk about. And this is not really IP in a legal sense. So anyone here who's a lawyer might be saying, that's not IP. That's not actually a property in the legal sense. That's true. But for businesses, I look at them as a part of your broader IP strategy. There's a lot of things that your business may have that's not creative in the sense of copyright. It may be an idea, it may be a strategy, it may even just be your numbers and the cost that you're paying for certain things. You may view that as commercially sensitive information. It's not really a trademark, it's not a brand name, it's not really copyright because it's not creative work, but it is still very important to your business, and you may view it through that same lens. So how do you protect that? Well, confidential information is the legal means by which you can protect sensitive information. And you also want to make sure in your business, what information do we have that is sensitive that I wouldn't want to get out, that I wouldn't want other people using because it's commercially important to my business. Might be your supplier list, your customer names, some of your the deal structures that you've done, the way you have designed your processes. The main way you protect those things is through contract. Again, confidential information is not something you register. There's no confidential information body. You just get a contract signed with the people that you want to keep the information confidential. NDAs, people will be familiar with this. This is called a non-disclosure agreement. It's basically usually a short form confidentiality agreement. You're about to tell somebody some sensitive information, and the document says, I'm going to tell you some stuff. By signing this, you promise not to tell anyone, or I can sue you. And that's a really powerful way to deter people from telling people the secrets that you're going to share with them. Similarly, most employment and contract agreements say any sensitive business information you come in possession of as part of your employment or contractor agreement must be kept confidential. You cannot leak it to others. You cannot use it for your own commercial benefit. And that's a very powerful way to stop employees learning about your business and stealing all of your confidential information. If you're working with investors or suppliers and you're a bit worried, oftentimes you can have a disclaimer on your pitch deck, big confidential symbol. People would have seen that, or on presentations. If you designate something as confidential, it's not as good as getting something signed, but it also actually has real legal force. If you've told somebody that something is confidential and then they disclose it, even if they never signed anything, you still may have a claim for breach of confidence. So there's various ways to protect confidential information, but just think twice about before you share confidential information about your business with anyone as to whether you have some form of protection. And again, similar to the other forms of enforcement, you can sue people for disclosure or for breach of contract if they breach your confidentiality agreements and so on. So that was most of the content I wanted to cover. I'm going to go through these remaining questions, and if people want to ask some more, you're welcome to stick around. I'll probably go for another 5 to 7 minutes. For those of you who are going to drop off, thanks so much for attending. As I said, if there's any help you need off the back of this webinar, do feel free to reach out to our team at sprintlaw.com.au. And if you are interested in these kinds of services, just mention that you attended the webinar, and we should be able to give you a discount for the next month or so. So thanks so much for coming. And yeah, I'll just dive into some of these questions, maybe starting at the top. So Lay asked earlier, how do I register and protect a software copyright? I think I answered that along the way, but yeah, you don't register your copyright in software. You just have to make sure that any employee that's written software for you has signed employment agreement with an IP clause in it, or any contractor or software developer that's worked for you has signed a contractor agreement or an IP assignment deed. Something needs to be in writing between your business and whoever made the software saying, I, the software developer, agree that all copyright will be owned by the business. You need that document. You need to keep that document, and you need some evidence that they're the one that wrote it, which is usually in the software logs. And those two things, this software developer wrote this software, and here's the contract saying my business owns it. That's how you protect the copyright, just those two documents. So you don't need to go register it, but you do need to document it. So hopefully that makes sense. Lawrence has asked, have you extended to other countries? I think I answered that one earlier in terms of international registrations. Larry asked earlier about trademarks. Should you register across industries? So we do data analysis software for hospitality. Should that be in both the software and the hospitality industries? And are there more costs for doing that? I think I also answered that one along the way, but the answer is yes. Often you should consider doing multi industry registrations. In your case, yeah, there could be a couple of classes for like there's a software class, and I think there's also a business analytics class. So it could be more than a couple of classes. You have to pay extra for each class. It's a little more. It's not double the cost, but it's a bit more. But it gives you broader protection. So it's a choice for you. If you don't do multiple classes, then you won't have as broader protection. You'll only be protected in the industries that you're registered in. But the more that you register, the broader the protection. And again, a lot of the advice trademark lawyers provide, because you can self-serve a trademark registration, but we often help advise on this exact strategy, what classes to go with. Should I just do one? Should I do multiple? And is it worth it? So that might be something to get some advice on. Jermaine's asked, where can I check the register? If you just Google IP Australia trademark register, you can search the register. And there's also that TM checker tool I think I showed earlier, which is a easier way to check the register than the general trademark search. Tessa's asked, do you have to be active in defending a trademark to keep it? E.g., if I have a trademark registered and someone else keeps using it, or someone else is using it, but it's not affecting me, could IP Australia decide to remove my rights to my trademark? So you don't have to be active in defending your trademark. And many people choose not to spend money on legal fees in defending it. But you do have to be active in using it, because there can be cases where if you register a trademark and you're doing nothing with it, you're just sitting on it, sort of squatting it, people can file what's called an application for non-use and attempt to get your trademark deregistered. You can defend that and say, oh no, I'm planning to launch soon. And IP Australia are usually quite sympathetic to non-squatting of trademarks. But it's more about use. Defense is not a requirement. And many small businesses don't have the funds to go defend their trademark and only choose to do so in egregious cases. So yes, you don't have to be out there defending it all the time. You just have to be using it, which if it is your brand name, you likely will be anyway. Sandra said, when they've accepted the application to be fast-tracked, what part are they fast-tracking? Is it only the 2 months to allow for anyone to argue the trademark? I assume by fast-track you mean the Head Start process. So the Head Start process is it's not faster in general from beginning to end, but what's faster is if you don't do Head Start, you'll file the application and it might take a month or more for IP Australia to give you the report saying it's approved or denied. With the Head Start process, usually in 1 week, they won't tell you the final outcome, but they'll say we're likely to accept or likely to reject. So you find out very quickly, rather than having to wait a month or 6 weeks, whether they're going to likely to approve it or not, and that can allow you to change it and so on and so forth. It's much faster to test, and that's why a lot of people choose to use it. Can you trademark a community newsletter name from Cash? Yeah, absolutely, you could, as long as that name met the criteria for a trademark. It was, original, wasn't descriptive. You found the right class for it. It wasn't registered by someone else. You absolutely could. Yeah. Sandra said, is it correct that through the application you use the TM and then the R when it is completed? Yes, that's correct. I didn't actually cover that in the presentation, except briefly. So people would have seen the little TM symbol that people put next to trademarks. That's an unregulated symbol. You can use that whenever, before or after you have a trademark, while it's pending. You can say, I intend for this to be my trademark, but I haven't yet got it registered. And that will at least be a deterrent for people and also help to build a little bit of brand credibility. The actual R symbol can only be used when it's completed, and you can be fined if you use it before it's completed. Is there a specific place to put the letters? There's no legal place to put the letters. It's usually done next to your logo. Um, and yeah, you would have seen, obviously from other logo designs, people often put it at the end of the sentence, but some people put it in the near the logo badge and so on and so forth. So that's more of a design question. Michael's asked if I have a company with a registered trademark and I want another company of mine to utilize that trademark sometimes with modifications. How does this work? Um, Technically, you would want to have like a license agreement between the two companies. Company A says, "Hey, here's our trademark. You, company B, are able to use this trademark and adjust it however you like, and we, company A, won't sue you." Now, if you control both companies, company A is probably not going to sue company B, and IP Australia is not going to come fine company B for using company A's trademark if company A doesn't complain. So if you truly control both companies, you probably can just go ahead and do it. If they're sort of separate businesses with separate stakeholders, the correct thing to do would be to have a trademark license agreement, and then that other company could rent the right to use that trademark. And that's very common, like Sprintlaw, for example, have allowed many businesses to use our trademark because they're affiliate partners, and we sign a contract saying, we license you to use the trademark for a period of X years, as long as you check with us any modifications. So you can totally license it for other people to use under an agreement. Larry said, what is the scope for there to be a copyright infringement? How close can another software be before it is an infringement? It's a good question, and not easy to give you a black and white answer. This is how technology lawyers make a lot of money, is advising on this very question. To give you some broad principles, software code that's generic and not original, a login feature that uses the same login technology as every other login feature, even if someone wrote it from scratch, um, uh, and then someone wrote it a very similar way, it's unlikely to be original enough if it was copied. Unique features may be more easy to be copied. It's not about exact copying. It's not even about 80%, 50%, 30%. It's about, was the bit that was copied original and creative? It could be a tiny little function, but if it was completely original and someone else copied it. Now, in most software cases, if you read them, they actually don't consider the design and the user interface in assessing infringement. I think the law might change because we're now in an era with AI where you're seeing a lot of softwares be essentially duplicated with maybe the code underneath is totally different to the original, but it looks the same. But traditionally in software cases, they looked at the two lines of code side by side to figure out how similar they were. And so there's many cases where things had similar functionality, but they were coded differently, and was not considered software infringement. In some cases, it was considered graphic design infringement, like this button is clearly got the same kind of animation as this other button, and so on. There's been some cases like that. But yeah, it's not a straightforward answer. But in general, if you're coding software, I think if you're going to be copying stuff, make sure it's open source or it's very generic. And if you're coming up with something original or copying something original, you just want to make sure that it's not going to be, you've got permission to do so, or otherwise you might want to rewrite it from scratch to reduce the risk of infringement. Some great questions here. If we post things on, e.g., Instagram, TikTok, etc., is a copyright owned by us or them? So the answer to that question depends on the terms and conditions of Instagram and TikTok, but generally, those social media platforms allow you to retain the right, like the ownership in the copyright. You're basically just giving them a license or a right to use it, and it's a very broad one. It's in their terms and conditions somewhere. So if you look at Instagram's terms and conditions, it says you, the user, agree by uploading this post to Instagram. You'll still own it, but Instagram has the right to distribute it, to show it to everyone, blah, 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 et cetera, et cetera. A lot of them allow you to take it down and then they'll stop distributing it. But that's how they get the rights to use it. You're not necessarily transferring it to them. There's some examples of apps that like will make a new photo for you or do something creative to something, and some of those platforms do take ownership, but in general, they allow you to retain ownership, and it's just a license. We've got a question: using for business education purposes IP that was created by state or Commonwealth governments, can these be freely used by my business? That's maybe is the answer to that question. There's maybe two considerations. One, what do the government terms and conditions say? Lots of government content, they allow businesses to use it under a Creative Commons license. So you'd have to go check the website where it came from or contact the organization. They usually allow their materials to be used. There's also an exception to copyright infringement for education purposes. If you're not commercializing it, there's some narrow exceptions, which is how universities, for example, are able to reproduce copyright content in lectures. But if you've got a business purpose in there, you usually don't qualify for that exception. So you just got to check the state or Commonwealth government terms. Sometimes they allow people to use their sheets. I mean, IP Australia, for example, I've used a bunch of their slides in here, which they have a Creative Commons license to use, and they expressly gave me permission to do so when I spoke to them. But it's totally possible they could have said this slide I'm showing you now with their logo on it and so on. They could have said, no, you can't use this. And so it's something you need to check on a case-by-case basis. Larry said, can an AI agent who writes the code also hand over the copyright of that work? So instead of an employee? Yeah, I mean, this is one of the big unresolved questions that lawyers are dealing with right now. Right now, in Australia at least, copyright requires a human author. So the AI agent can't own the code. So who owns the code if you write something with ChatGPT? Well, again, I'll give you an opinion on how that might play out rather than what I could say is a definitive answer, because this is an unsettled question. But it depends on two things. Well, a few things. Was the code that the AI produced original, or was it just like a boring login screen, in which case there is no ownership? If it was original, what are the terms and conditions of ChatGPT or Claude say? A lot of the time, they actually say, we will give you, the user, ownership in any copyright generated in your chats. A lot of them are quite generous, but not every LLM is like that. And then three is the prompter coming up with the originality. And if somebody who originally prompted an AI to generate code under terms and conditions that allowed them to own it, then that human, I think, would have a decent case for saying, under current law, even though an AI helped me, I own this code. That's how it works today. That said, if the AI was trained on some infringing stuff from, I don't know, Stack Overflow, one of those coding websites, and it reproduced someone else's copyright, and then that shows up again in your app, that person could potentially still sue you for copyright infringement because you've reproduced their copyright. So you may not actually own it if the AI didn't generate it sort of from scratch. So it's a difficult question, and there's a bunch of court cases outstanding. But yeah, that's probably the best answer any lawyer could give you right now in about 30 seconds without writing a long academic paper on it. Tanya said, I'm a First Nations Narrandjeri florist. I create floral arrangements that reflect culture and country. How do I ensure the cultural knowledge is copyright protected? I would like to prevent misrepresentation and have people use the cultural knowledge for their benefit. It's a great question. It's probably a bit specific a question for me to answer in the webinar. I guess what I could say is there's been a lot of discussion in copyright law around how to deal with traditional cultural knowledge and Australian IP law. So like there's been cases where cultural expression has not been fully or easily protected under standard copyright law unless they meet the requirements of the Copyright Act. But then that's been challenged in various court cases. So, usually for the arrangements, if there's ways that it can be fit within the Copyright Act's definitions of, photographs of the arrangements, or videos of the arrangements, or original versions of the arrangements, those things would be fairly clearly protected. If you have sort of clear cultural use statements, and so on, and then people are reproducing it and reusing it without your permission. There may be non-copyright claims you can make against them, misrepresentation, and so on. So you can end up with some fairly solid protection under IP law. It may not be around the arrangements themselves, but it may be around, photographs of them or content around them, of which themselves, the photographs and the content may be protected. So hopefully that makes some sense. And again, if you want a bit more specific advice, might be worth reaching out to the team for a consult. Um, uh, yeah, and I can see you saying, yeah, you share the Aboriginal use of that plat in the floral arrangement. Yeah, so it'd be interesting to know whether that content that you provide is copyright protected. And again, I probably can't answer that in the abstract, but potentially it would be protected. It just would need, yeah, a bit of advice. Cash said, if not a member, how much to get you guys to do a trademark from start to finish? It depends on the number of trademarks in the classes, but if it was one trademark in one class, I think it's 750 or $800 or something like that. So yeah, but you can reach out to the team for a quote. And again, I think we're doing discounts at the moment if you wanted to get something registered. We're getting there. Lots of questions. Looks like we've got, yeah, um, 5 or 6 left. How would you report the R symbol being used by a copycat business to IP Australia? This business does not have a trademark application lodged for this phrase after checking on IP Australia trademark search. Interesting. Yes. IP Australia, I think, do accept the complaints. They don't have an aggressive enforcement arm. So it may be that they would send a cease and desist to the copycat business, or you could potentially send one. If you own the trademark or something similar to the trademark, and they're now using the registered symbol when it's actually yours, you certainly would have the right to send a cease and desist letter. If you've just noted a business using it and you can't see that they have a trademark, um, claims could be made against them for misrepresentation if you were a customer, or if you could show some loss because you thought they were a registered brand or they weren't, and IP Australia could potentially enforce against them and issue a fine or a penalty. So yeah, you may want to contact IP Australia and ask what they would do in that case. Or again, if it's directly affecting your business, you would certainly have the right to get lawyers involved and send a letter. Okay, Tessa's asked, how does selling fan art for once-off commission work with IP laws in Australia? E.g., if I was selling my creative skills for making unique physical products and someone commissions for something in the theme of something they're a fan of, can I use the likeness of Disney princess to do that? It's a product that doesn't exist. Okay, I see what you mean. So it's fan art, and somebody wants you to use something that's probably trademark or copyright protected. That's a tough one, and again, it's an issue. We've had this question before from clients, and again, I'm reticent to provide specific advice in a webinar, so you might want to get some specific advice on that one. In general, there are problems with doing that. You're essentially commercializing someone else's trademarks and IP without their permission, which is could be a black and white case of copyright infringement. And even if the physical product doesn't exist, like it's a new toy, for example, that they never produced, intellectual property is by definition intellectual. So if you're using their intangible rights, then that could be infringement. Now, I said earlier to another question, there's no trademark or copyright protection for a likeness or a character or a vibe. It's more for, like, the name Mickey Mouse would be trademarked. Certain designs of Mickey Mouse would be trademarked. But if you made a mouse that had the same vibe as Mickey, they'd have to show that you'd use Mickey Mouse's name or one of his registered pictures, or some copyright version of him to show that you had infringed the Mickey Mouse rights, which, if it really looks like Mickey Mouse, there's a good chance they'd get you on copyright infringement, unless, the drawing is really quite unique. In practice, a lot of these companies are not going after small scale creators selling things. They might start doing so in the future, again, with AI that can possibly detect stuff all over the internet. So it's possible that you could get some automated cease and desist from Disney if you're putting it on Instagram and so on. But they may not bother. They tend to go after like bigger creators. So it'd be risky. And again, I think if it's part of your business, you just want to maybe get some advice on what you can and can't do and where the line is and how to protect yourself from potential claims, if that makes sense. But yeah, not a straightforward one, that one. Um, okay, I'll get through these three more questions. These are good questions. Cash has said, what is required if doing custom workflows for a client as a media marketing business to improve their efficiencies, marketing, social media posting, SEO, content marketing? Yeah, so look, usually if that's what your business does, you would have a client agreement or a service agreement or a marketing services agreement which your client signs. And that in the relation to intellectual property would usually have an IP clause. Usually, if you're the service provider, it's better for you to say, I'm going to improve your efficiencies using email marketing workflows and processes and procedures and know-how that I've developed. It's mine. You agree to keep it confidential and not commercialize it yourself. And to the extent that any of it is copyright protected, I still own it. And that would stop your client being able to take these ideas and build their own business off the back of it. That might be too harsh. And what you might say is, I'm going to make stuff specific for your business, which you can own, but you give me the right to use these ideas with other clients. And that might be the right middle ground. But you want to have some clarity in there around how it works. Is this just for them, or are you allowed to use stuff for other clients? Oftentimes, these kinds of agreements have a concept of existing IP and new IP, which says uh, to the client, anything that I created before I took you on as a client remains to be mine. Anything that we make together is yours, but you give me the right to potentially use those ideas for other clients. So yeah, we do a lot of that drafting. So if you want some advice on that, again, we can draft your client agreement handling those issues. Craig said, what's the typical timeline for applying for a global trademark through the Madrid Protocol? Well, Madrid's more of a filing system rather than it actually. So to be clear, you can't file a global trademark. You'll file in Australia, and then you'll go through Madrid to select, okay, I want to do US, Canada, and a couple of other countries, and then you're essentially filing with each of those countries' IP bodies, and you'll receive a response from the US um, trademark office and the UK trademark office at the end of the day if you're successful. So the timeline varies for each Madrid application. If you pick the US, the UK, and Canada, Canada can take an extremely long time, like up to 2 years in some cases. UK can be quite quick. Could be 3, 6 months. US can be 6, 9 months. So they're all different is the answer to that question. Most of it's done within a year, but some could take, as I said, up to a couple of years. So all the better to do it sooner rather than later. And then Lauren said, if a logo is essentially a word, does the logo itself need to be registered? Depends how similar they are. Most small businesses don't bother doing the logo if the logo is just the word because you don't really get extra protection. In our case, we did the logo because we have that like S shape, I think I showed earlier. So we wanted to protect that in addition to the word. If you got a very unique, I mean, we have this little slash on the T and the L, so we also get that, which wouldn't be picked up in the word mark. It just depends on how similar it really is. But I'd say most small businesses save the money if it really is just the same in typography because you're not getting any extra protection. Okay, well, lots of great questions, and hopefully people found that all very, very useful. And yeah, look forward to seeing you again for our webinar next month. In the meantime, all the best.